Welcome back everyone. This is Attorney Mahmudul Hasan again on the EB1S series. In a subsequent part, we will discuss your questions and answers in a question-answer format, but this is the last part of our formal EB1S series. In this part 14, we are going to discuss how you should organize your petition, what you should consider before you file your EB1A petition, what you should expect after you file your EB1A petition, including a request for evidence, how you should respond to your request for evidence, what happens if your petition is denied, and what you should do if your petition is approved. Let's go to the discussion. Form I-140 Immigrant Petition for Alien Workers is the form that you will submit for the EB1A classification. Please remember, the Form I-140 you are submitting just defines or introduces the classification you are seeking. The form does not have any place where you would discuss your extraordinary ability. To discuss or articulate extraordinary ability, different people might have different strategies. Immigration attorneys generally submit a legal support letter where we explain the legal and regulatory requirements of the EB1A classification and compare how the petition we are filing meets those legal requirements. We provide evidence in support of our claims in the legal support letter and reference it in the exhibits. Immigration attorneys also recommend to submit a personal statement. A personal statement for an EB1A petition should be a concise, well-articulated narrative that outlines your professional background, key achievements, and the depth of your expertise in a non-technical language. It should be like a storytelling. You should provide a personal perspective on your contributions to your field, highlight the significance of your work, and explain your career goals, particularly how they relate to your aspirations in the United States. Also mention how you plan to continue your work in the field of extraordinary ability in the United States. It is human nature, especially for overachievers, to be modest about their own accomplishments. However, this is the place where you should highlight your achievements and background. This statement serves as an opportunity to personally connect with the adjudicator, presenting a compelling case for your qualifications beyond what can be inferred on your resume or formal evidence. Next, submit an updated and detailed resume that outlines your education, qualifications, and professional background. Include your detailed roles and responsibilities, projects you have completed, patents you hold, papers you have published, and media outlets where you have been featured. Highlight awards you have received, your professional memberships and affiliations, and any certifications you hold. Additionally, include other roles such as founder, creator, or contributor, and describe your significant contributions to the field. Don't forget to list any public speaking engagements, conference presentations, workshops, and any involvement in industry panels or boards. Finally, mention any community service or volunteer work related to your profession, as well as any mentoring or teaching roles you've undertaken. Finally, please ensure that the letters of recommendation and exhibits are arranged in the order you mentioned and argued in the legal support letter. Once you have prepared your Form I-140, legal support letter, personal statement, exhibits, and letters of recommendation, please verify the current filing fee and the correct filing address on the USCIS website. Keep in mind that filing fees and addresses are subject to frequent changes. Now, a common question is whether you should opt for premium processing, which generally guarantees a decision within 15 days but requires a higher premium processing fee. We generally do not recommend it because we have observed in a number of cases where premium processing leads to a big request for evidence, where the USCIS officer asks for evidence that has already been submitted with the petition. It might not be true for many cases, but if you are in a situation where you are required to do the premium processing, it is of course your decision to make. Once you submit a petition, USCIS issues a receipt notice with a receipt number and priority date. The next thing USCIS might issue is either an approval or request for evidence. USCIS generally does not deny a petition if your initial petition is deficient in any evidence. Instead, they usually issue a request for evidence. Do not get panicked when you receive a request for evidence. because it is an opportunity to fill any gaps or deficiencies in the initial petition. For instance, if you submitted certificates of awards, but USCIS thinks the documents you submitted to demonstrate the national or international significance of the award are insufficient, they might issue a request for more evidence on the national or international significance of the award. If you submitted the major significance of your contributions, but USCIS is unsure whether the contributions are your original work, they might issue a request for evidence asking evidence to demonstrate the contributions are your original contributions. They might also issue a request for evidence if the evidence does not clearly show national or international acclaim when they assess it in the final merits determination. Additionally, USCIS might seek further clarification on your role in key projects or require more evidence of a specific background. They might issue a request for evidence for silly things. For example, you did not mention in your initial petition that you will continue working in the field of your expertise in the United States. A request for evidence letter will generally describe what is missing in your petition or what documents you might need to submit. USCIS generally allows 60 to 90 days to respond to a request for evidence. Read the request for evidence carefully to determine what it is asking for. You might consult an experienced immigration attorney because sometimes the language of a request for evidence might be technical. Once you respond to the request for evidence, USCIS will issue a decision. It might be an approval or it might be a denial. If it is denied, the denial typically specifies the reasons. For example, the denial might state that you have satisfied 2 criteria but not the third one. Or it might mention that you satisfied at least 3 criteria but did not demonstrate your sustained national or international acclaim. If denied, you have the right to file a motion to reopen or a motion to reconsider or both with USCIS. A motion to reopen is generally based on new evidence you have. For example, if after the filing of your petition you receive a new award from recognized international institutions, this could constitute new evidence that potentially fills the gap in the denial. A motion to reconsider, on the other hand, is filed to request review of the decision based on alleged errors of law or fact in the original decision. For instance, USCIS has denied your petition on the grounds that they believe the award you received does not have national or international significance. But you believe that USCIS decision involves a misinterpretation of the legal standards pertaining to what constitutes national or international significance, or they have overlooked or misapplied specific legal precedents that favor your case. Then a motion to reconsider would be the appropriate course of action. You can also do both, where you submit new evidence and argue the alleged errors of law or fact in the denial. Alternatively, you may appeal to the Administrative Appeals Office. The Administrative Appeals Office has de novo jurisdiction to adjudicate whether you submit new evidence or a legal brief. It means they have jurisdiction to adjudicate the petition starting from the beginning as a new petition disregarding the finding of USCIS. You generally have a deadline to submit a motion to reopen or reconsider or appeal to Administrative Appeals Office. Please follow the instructions on the denial for deadline and your other options. Now, if the petition is approved, congratulations to you. You have moved the heaviest rock in US immigration. Please remember that an approval of the petition creates the way for a green card but is not the green card by itself. You have to apply for the green card separately. This is a snapshot of what you will need to do to apply for your green card, and we will discuss the details in separate videos. If your EB-1A is approved, your next steps will differ depending on whether you are inside or outside the United States. If you are inside the United States, you will need to submit an application for adjustment of status. If you are outside the United States, you will undergo consular processing. We will discuss the details of adjustment of status and consular processing in separate dedicated videos on them. Please follow us. Also, you must check the visa bulletin to see if a visa number is available for the priority date you were given. We will also dedicate another lecture to the visa bulletin. The visa bulletin will determine the appropriate time to apply for your green card. Depending on the availability of visa numbers in the visa bulletin, In some cases, you can proceed with a concurrent adjustment of status with your initial EB-1 petition if you are in the United States. In other cases, you have to wait for the visa number to become available.
We have come a long way from part 1 to part 14. You have stayed with us for this long hours and technical discussions. I appreciate your patience for this. I believe the information was helpful for you. We appreciate your feedback and comments. If you would like to hire my service for your EB-1 petition, you can contact me. You can find me on Google, Mahmudul Hasan, immigration attorney. Please consult an experienced immigration attorney who can give you an exact advice you need for your EB-1 petition. Please stay with us. Follow us on Facebook, YouTube, LinkedIn, and other platforms. Thank you very much.